The Citizenship Amendment Act is a limited amendment that has been undertaken to the legislation for the specific reason of vesting citizenship or undertaking the process of naturalization to persecuted minorities in 3 specific countries, namely Pakistan, Afghanistan and Bangladesh. There is a specific cutoff date that has been identified in this particular amendment legislation, which is that those people who have entered India before the 31st of December 2014 are meant to be the specific beneficiaries of this particular amendment. Contrary to popular perception, it does not introduce religious criteria into the fundamentals of the Citizenship Act. It uses this criteria specifically in the context of the 3 countries which have been identified for the purposes of identifying who amounts to a persecuted minority community. The framing of this entire issue as exclusion of Muslims is a fundamentally flawed issue. This is not about exclusion of Muslims, this is not about exclusion of any community whatsoever. The object of this particular legislation or this particular amendment is very simple, specific and limited, which is it is inclusion of those people who amount to persecuted minorities in these 3 countries. Point number 1, which is to be noted very clearly as far as this act is concerned, is that there is no reference whatsoever to exclusion of Muslims even from these 3 countries. However, the distinction that is sought is this: individual citizenship versus recognition of a group as being entitled to citizenship. This particular act identifies 3 groups and does not take away the right of any individual Muslim from any of these 3 countries from applying for citizenship, asylum or refuge under Indian laws. Therefore, this is not an act which is meant to be treated as a legislation for exclusion. This is an act for inclusion. That is the primary distinction. The media has gone on and on about this particular legislation being an instrumentality of exclusion. This has got nothing to do with exclusion whatsoever. Historically, these 3 countries have had significant Indic populations coupled with non-Muslim populations, and there has always been a question of what is it that India is supposed to do. Does it owe any duty to those populations which suffer from any kind of persecution, specifically religious persecution in these 3 countries? In fact, one of the most important documents that one needs to look into for this particular purpose is the Nehru-Liaquat Pact of 1950, where both these countries had specifically given each other the assurance that the religious minorities of the respective countries will be taken care of and their rights will be protected. The premise of this particular pact was what is known as the critical hostage theory, which is to basically say that religious minorities in both these countries shall act as hostages to the other country for the purposes of ensuring that their religious minorities are protected. So for instance, if Muslims in India are to be protected and treated at par with other citizens, then Pakistan wanted to retain a set of non-Muslims in Pakistan so that it is in a position to bargain for the safe treatment and equal treatment of Muslims in India, and therefore vice versa. This is the premise of this entire act. 3, as far as undivided India is concerned, prior to the partition of the country, these were all part of the same subcontinent, they were all part of the same undivided India. Therefore, India has a specific constitutional as well as civilizational obligation to these persecuted minorities. And it is a fact that prior to 1971, the population of non-Muslims in undivided Pakistan was 23%, which fell to 3% in Pakistan and 20% in Bangladesh post the partition. And subsequently, that number has only dwindled. So when the argument is being made that from 1.6% it has increased to 1.85%, that is the population of Hindus in Pakistan, they forget that it has fallen from 3% to 1.85%, and that is the big picture that nobody talks about. Similarly, as far as Bangladesh is concerned, from 20% it has now come down to close to 10.7% if my memory serves me right. Therefore, there are only 2 ways or perhaps 3 ways in which this particular population has vanished. 1, they've run away from Pakistan and Bangladesh to some other part of the world, which includes India, or they've been subsumed in the population, losing their non-Muslim identity, which means they've been converted. 3, they've been killed. These are the only 3 options possible to the best of my understanding. No other option explains the radical and revolutionary decline of their figures in both these countries. Now that takes us to the question of Afghanistan. Ever since the ugly head of Talibanization reared its head in Afghanistan, it is a fact that it was set up as one of the most radical Islamic regimes ever known in the history of the world. Perhaps, according to me, that was the predecessor to the Islamic State. And that particular regime made it a point to go after everyone who did not subscribe not just to Islam but also their version of Islam. And that's one of the reasons when Afghans were actually fleeing that country, India decided to open its doors both to Muslims as well as non-Muslims. The question that can be asked is, why doesn't that logic apply to Ahmadiyas and Shias in Pakistan? So why should India strike a distinction between Afghans who were fleeing Talibanization and Ahmadiyas and Shias and Sufis who are trying to flee Pakistan because they are not seen as being Muslim enough? The argument there cannot lose sight of the historical backdrop that regardless of the sectarian violence within Pakistan, each of these avowedly and admittedly Muslim groups, so to speak, within the Muslim community or Muslim sects have had a specific hatred for and animus for non-Muslims, specifically idol worshippers such as Hindus. Therefore, there is no point in actually equating Ahmadiyas, Shias and Sufis of Pakistan with the Afghans who were fleeing from Talibanization. Point number two, the question that India has the legitimate right to ask, and I dare say it must ask, is would bringing any population from any other part of the country endanger a significant population or significant portion of the Indian population? Therefore, if Ahmadiyas, Shias, Sufis or anybody else who subscribes to Pakistani version of Islam because we believe that there is an Indian version of Islam, if they come to India with that specific animus, they pose a danger to 80% of the population at the very least. And most importantly, what people don't realize is that Indian Muslims, a significant number of them, have a problem with Bangladeshi Muslims as well because they're taking away their jobs as well. Therefore, this entire monolithic approach to this discussion, according to me, is downright stupid and ignorant of the basic facts. The only constitutional argument that is being used in this entire debate, I would say it is a downright stupid argument to anyone who understands how the Constitution works, is the use of Article 14. If Article 14 is to be interpreted in the manner it actually reads, before we apply it to the question of citizenship, what it is certainly going to do is to render 1,000 different schemes that bestow minorities with different treatment, with special treatment, with differential treatment, unconstitutional. That's point number one. Point number two, if this is all there is to it as far as Article 14 is concerned, then perhaps constitutional law should not be the preserve of constitutional experts. Anybody and everybody can sit and interpret a constitution basically by just reading the provision of the constitution. I don't think that's how it works. 3, Article 14 uses and applies the concept of equality by identifying which group are you applying the test of equality. Therefore, it is a question of the sample. Therefore, if there are similarly placed people, are you treating them at par with each other? That is the test of equality, but not treating unequals equally. Therefore, the trigger or the motivation behind the persecution of Ahmadiyas or Shias in Pakistan is not the trigger or the motivation behind the persecution of non-Muslim minorities in Pakistan, Afghanistan and Bangladesh. One has a sectarian basis, the other has a religious basis. Therefore, the samples are completely different. This is what amounts to what is known as a reasonable classification for the purposes of Article 14, because one, it doesn't suffer from over-inclusion, it doesn't suffer from under-inclusion. It specifically addresses the target audience which has been selected on the basis of an identifying metric, which is to say, who amounts to a religious minority in Pakistan, and is that particular minority being persecuted on religious basis? Now, therefore, that takes you to the question, what about the Jews in Pakistan? I'd actually like to ask myself this question, are there any Jews left in Pakistan? That is the question that needs to be asked before we start inventing these speculative hypothetical questions by inventing a group whose existence has been completely destroyed in the state, in the Islamic Republic and the holy land of Pakistan. So this argument, according to me, does not hold water. Assuming for a moment that this particular amendment did not include the Christian minorities of Pakistan, then perhaps a question could have been raised. But even then, the one thing that people have not even taken note of, which is they have not even read the Amendment Act. The Amendment Act specifically says under Section 6B that even in granting citizenship to these persecuted minorities from these 3 countries in India, enhanced obligations can be imposed on them in the grant of the citizenship, which will continue to apply even after they have become citizens, which is to say, some citizens who are refugees turned citizens cannot be treated at par with other citizens because they have undergone the process of what is known as naturalization. Therefore, this argument of Article 14, if it were to be applied, that means even those people, these minorities, these persecuted minorities who come from Pakistan, Afghanistan and Bangladesh, if the Article 14 logic is to be applied, India does not have the power to actually employ higher standards. Why does India have the right to employ higher standards? Simple. What is the guarantee that the person who comes to India is truly a Hindu, Buddhist, Jain, Sikh, Christian? How do we know that for a fact? Therefore, if they have lied in the process of seeking naturalization or citizenship in seeking entry into India, and that lie is detected at a later point of time, then India can prosecute them. Apart from that, until they have settled in this country and until authorities have had an opportunity to monitor their activities in this country, they shall continue to be under the radar of the government. That is why these enhanced obligations are imposed. Nobody has even highlighted this particular fact, because if the Article 14 logic is applied, there cannot be any enhanced obligations that are applied on them. Therefore, this use of Article 14, according to me, is an irrational, irascible, emotional argument which has absolutely no basis in constitutional law. No sane student, practitioner, or let's say a follower of constitutional law can subscribe to this dumbed down version of Article 14, which even the Supreme Court cannot entertain at all. Therefore, there is absolutely no basis. There could be perhaps any other challenges to the constitutionality of this particular legislation, but Article 14 cannot be the ground for that particular challenge. So far, I have not heard any of these detractors highlight any problem with this particular act other than the much touted Article 14. I don't think there is any basis in that particular objection at all. So the question that we have to ask, dehorse all the emotional points and civilizational points or rhetorical points for a moment, is what is the legal position that applies to the grant of citizenship under the Indian Constitution? Which are the legislations that one is supposed to look at? Point number one, Article 14 is not the provision that deals with the question of citizenship. Article 14 falls under Part 3, whereas Part 2 of the Constitution, which is Articles 5 to 11, are the specific provisions that deal with the question of citizenship. Most importantly, the question of citizenship is not addressed entirely in the Constitution, because Article 11 specifically says that the grant of citizenship shall be subject to any further law that the Parliament may pass in this particular regard. One, that effectively means that it is only the Union Parliament or the Parliament which has the power over this particular issue. It is not within the domain of the states. So the states have no other option but to follow the rule which is laid down, or the law which is laid down by the Parliament in this regard. That is point number one. Point number two, therefore, the law in question becomes the Citizenship Act. Therefore, Articles 5 to 11 must be read along with the Citizenship Act of 1955, coupled with the Foreigners Act of 1946, because that deals with the question of who is a foreigner as far as India is concerned. Now, then what is the interplay between these set of provisions and legislations and Article 14? Article 14 obviously does not limit its application only to citizens, it applies to non-citizens as well. There is no quarrel with that particular proposition. However, in interpreting and applying Article 14 to non-citizens and to persons who are not citizens, you have to take into account the other specific provisions that deal with the question of citizenship. Because the general principle in law is that if there is a general provision and a specific provision, that provision which has the closest proximal relationship to the issue must be the provision that must be looked at. Therefore, the provisions would be Articles 5 to 11 read with the Citizenship Act and the Foreigners Act, and not the provision under Part 3, which is Article 14. The Foreigners Act effectively then takes us to NRC. The Citizenship Act takes us to the Citizenship Amendment Act of 2019. That's point number 2. Point number 3. When the Parliament, or rather the Constitution, has given the Parliament the power to pass a legislation, it also means that so long as the Parliament passes a legislation which grants citizenship, which does not militate the spirit of 5 to 11, that particular provision or that particular amendment under the Citizenship Act must be treated as constitutional. This again takes you to the question of whether the Government of India or the Parliament has undertaken a certain amendment which completely revamps the Citizenship Act by saying only Hindus shall be granted citizenship in India, or any non-Hindu who seeks citizenship into India shall necessarily have to convert to Hinduism. 3, that no Muslim shall be given citizenship as far as India is concerned, or 4, Indian Muslims shall be deported from this particular country, when none of these points are actually said in the Citizenship Amendment Bill, or which is not even the object of the NRC, which people are scared of. It is surprising that this kind of fear-mongering has happened on the basis of something that has no basis in facts or law. Most importantly, the question that is being asked over and over again is, if people, or rather if the government undertakes a nationwide NRC and Muslims stand excluded from that particular exercise because of the product of that particular exercise, and Hindus also stand excluded as a product of that particular exercise. Apparently, the Citizenship Amendment Bill will protect the Hindus and not the Muslims. This has absolutely no basis, because the Citizenship Amendment Act applies exclusively to Hindus, Jains, Sikhs, Parsis, Buddhists and Christians coming from Pakistan, Afghanistan and Bangladesh, and who have been in India before 31st of December 2014. So clearly, the Citizenship Amendment Act of 2019 is not broad enough to encompass all those Hindus who may or may not be excluded by a nationwide NRC. Therefore, this linking or hitching of the wagons between the NRC exercise and the CAB has absolutely no basis. The CAB at best protects those people coming from the persecuted minorities of these three countries who have entered India before the 31st of December 2014 and who may be in the state of Assam for the purposes of application of CAB. Beyond that, to actually say that it applies to the entire country, it applies to all Hindus regardless of where they come from, has no basis whatsoever. Frankly speaking, this is the express language of both these legislations, the Citizenship Act, the Foreigners Act, the Citizenship Amendment Act of 2019 and Articles 5 to 11. Those media agencies who have specifically indulged in fear mongering, having complete knowledge of this particular structure, according to me, should be taken to task at the very least by the Press Trust of India or any self-regulating body. Because if you take them to court, if the government decides to do something, I'm sure people are going to say that this is an attack on freedom of speech and on freedom of media and freedom of expression, which it is not. Frankly speaking, the situation that is facing us today and the riots on the streets that we are seeing is not a consequence of the legislation, but because of the fear mongering that has been indulged in by specific dramatis personae, and the media has played a significant role. They had an obligation to inform people. They have actually indulged in rumor mongering.